Good afternoon and welcome to Ask Me Anything Employment Law. This session is part of the 2025 Rising Economy Conference, an immersive virtual and in-person event hosted by the South Island Prosperity Partnership. My name is Jeff Bray and I'm CEO of the Downtown Victoria Business Association, and we're proud to be a sponsor of this year's Rising Economy Conference. This is a conference that brings together thought leaders, business leaders, community leaders, to talk about our regional economy, talk about our region and its strengths and its opportunities as we look to lift our economy across the region for our current businesses, attracting new businesses, and really staying at the cutting edge of that makes our part of the world so wonderful to live in and so wonderful to do business in. So I want to just describe for you the format that we're going to have for today's session. In a moment, I'm going to turn things over to our speakers. But first, just a quick overview of this format. About halfway through the conversation, we'll be taking questions for our speakers. You can submit a question anytime through the Zoom Q&A below in this video. This session is also being recorded, and you can submit your questions anonymously if you do prefer. To interact with attendees, you can use the Zoom or WOVA chat. The production team will monitor the WOVA chat and Q&A for those joining us through the app. Finally, if you're posting your takeaways to social media, please use the hashtag Rising Economy Week 2025. It's now my pleasure to introduce somebody who's not a stranger to anybody I know who's joining this session, our session moderator, Kerry Slavens, who is the Director of PR and Engagement for the South Island Prosperity Partnership. She has focused her career on developing clear and compelling communications across multiple mediums. After graduating from UVic's Department of Writing, she worked at newspapers and magazines throughout British Columbia before co-founding Artemis PR and Design, a communications agency. As editor-in-chief of Douglas Magazine, where we first met, from 2011 to 2020, Kerry played a key role in telling South Bank of Ireland stories of innovation and of entrepreneurship and shaping the vibrant business narrative of this region. Kerry was also editor-in-chief of YAM, a lifestyle magazine, and Spruce, a home and renovation media brand. Over to you, Kerry.
Thanks, Jeff. It's always great to see you, and thanks for making our downtown better every day. Well, welcome, everybody. Good afternoon. Again, we're here for the Ask Me Anything Employment Law in British Columbia panel. And if you have burning questions about workplace rights, employer obligations, or navigating tricky employment situations or disputes, this is your chance to ask questions straight to two of our province's best labor and employment lawyers, who I'm going to introduce in a minute here. I've known of both of these women for the past couple of years, and I can tell you that they really know their stuff. They are very sharp when it comes to employment and labor law, and we're just very lucky that they've agreed to be here in this format. And I should emphasize, this is an Ask Me Anything format, so don't wait for halfway through to submit your questions. You can start right away, and I will pick them up from the Q&A on Zoom or the Whova app as they come through, and I'll try and sort through so we don't get duplication. I'm thrilled to have the opportunity to interview Jessica Thomson and Marcia McNeil of Pulver, Crawford, Munroe, LLP. Jessica Thomson is a partner at Pulver, Crawford, Munroe. She's a trusted advisor in labor and employment law, known for her strategic and practical approach to complex workplace matters. Jessica advises employers across both public and private sectors operating within the provincial and federal jurisdictions. Her work spans government, post-secondary, education, tech, oil and gas, financial services, and more. Marcia McNeil, also a partner at Pulver, Crawford, and Munroe, has practiced in the areas of labor, employment, and human rights law since 1990 and represents employers in both the public and private sectors, particularly municipalities, police services boards, and high tech. She has been recognized consistently since 2012 in the Canadian Law Expert Directory for her work in employment law and has been recognized since 2020 in the best lawyers of Canada in the fields of labor and employment law. Welcome, both of you. I invite you to turn on your microphones and your videos. Well, it's a pleasure to see both of you today, and I'm really excited about this session because it's not very, I think everybody has questions about the workplace, whatever side you're on. I've been on both sides of it, and it's just always fascinating. And I think we assume a lot of things. I remember a previous conversation talking to both of you about American TV shows and how we sometimes assume that applies to Canadian employment and labor law. And today we're going to find out some differences. So I'm going to start with a few questions here. Jessica, you've been practicing for a number of years. What shifts or trends are you seeing in today's workplaces that employers or employees are experiencing?
Yeah, so I think some recent changes, and good afternoon, everyone. Thank you very much, Kerry, for the lovely introduction. We're excited to be here and to be participating in this webinar with SIP. And I'll now jump to the answer to the question in terms of recent changes that we've seen. I think some of it's driven by, the pressures that we felt through the pandemic. And I think what we're seeing is an increased desire on the part of employees to obtain flexible work, and a desire on the employer's side to want to figure out how to offer it, but also manage all of their other obligations within the business. And touching on that, I've noticed a significant increase in the number of different people who are working remotely in a location, a province, or maybe even a country that is different from the employer, or vice versa. The employer is located in Victoria, but they're hiring people in other provinces to work remotely or in other countries. And I'm finding that people aren't turning their minds to the various issues that can arise when that arrangement is met. And certainly it can be done, but there are a number of things that should be considered and addressed at the outset to avoid issues down the road and to make sure that the laws are all being complied with. And finally, one other thing that sort of has been a bit of a shift and a change is an increase in awareness with respect to the notion of psychological safety in the workplace. We've got legislation, of course, in place that it serves to ensure that we, either your employees or employers, that there is a safe workplace for the employees to work in. And included in that is psychological safety. And so we're seeing sort of an increase in the number of issues arising with respect to that, either an increase in complaints that are being brought forward of harassment or bullying, allegations of a toxic work environment that are having an impact. But we're also seeing, and some of it's due to sort of the tensions and uncertainty that we're facing, I think, is an increase to some extent in discord. So individuals at work who are having, disagreements one with the other or whatnot, and that this might be rightly or wrongly playing into the notion of psychological safety at work.
Okay, that's interesting. And is that, I often wondered, people coming back to work into the workplace from after most of us were home during COVID, are we learning to get along again? I know that's not a legal question, but you're saying you're seeing an increase in discord. So can you attribute any of that to people being isolated from each other and forgetting how to get along?
I think there's something to be said for that, Kerry. Yes. Yeah. I think there's a sense of being distanced one from the other. And there's, when you're sort of typing your messages with your fingers and you're doing it through email or that the boldness that comes with that, sort of the notion that you might say something through an email or a text that you wouldn't actually say in person to someone face to face. And so we're sort of rebalancing some of that. To some extent, some of that's happening with the remote work. And then we're also learning how to engage with each other in the workplace face to face.
Exactly. Well, Marcia, I want to know, what questions do you get asked most often by employers and by employees? What comes up?
Well, with the events of the last few days and the last few months, certainly we're seeing a lot more employers and employees who are concerned about the potential for downsizing or restructuring of workplaces to take into account perhaps a downturn in business. And so we are often asked questions about what are the obligations of employers and what are the rights of employees in those circumstances. And there's a few sort of misconceptions that tend to prevail. One certainly is the idea that employers have a general right to lay off staff. And I want to distinguish between what's legally meant by the word layoff versus the word termination or severance of an employment relationship. A layoff occurs when an employer tells somebody that they don't need them right now, but expect to need them again in the future. And other than in the construction industry, that's not a general right an employer has. An employer doesn't generally have the ability to say to an employee, we don't need you right now. We're going to need you again in a couple of months. Please come back when business picks up again. Mm-hmm. Generally speaking, that is considered a termination of the employment relationship. And a termination of an employment relationship triggers an employer's obligations to provide an employee with notice or severance. Notice, when I say notice, what I'm talking about is saying to an employee, we're no longer going to need your services in X months' time, in 3 months' time, or in 4 months' time. Keep coming to work, keep doing your job. We'll keep paying you, but we won't need you after a few months down the road. Severance, on the other hand, is effectively saying, today is your last day. We no longer need your services, but we're going to provide you with some compensation to make up for the fact that that we're terminating your employment without notice. Mm-hmm. That leads to questions about what's the appropriate amount of notice or severance. That's an inevitable question in the circumstances. And we have 3 answers to that. At base, there is the Employment Standards Act, which sets the minimum amount that any employer must give. That is very rarely going to be what an employer actually owes an employee. There are some circumstances, perhaps in some retail settings or perhaps in hospitality, where that might be the case. But in most settings, employees are going to get quite a bit more than that minimum required under the Employment Standards Act. And to determine how much more, we want to look first to whether there's an employment contract that specifies how much notice or severance the employee is going to get. If that contract does specify and is otherwise valid, that's going to establish what the employee's entitlements are going to be. If the contract is silent, we look to the courts to tell us what's typical in this kind of case. And we look at the employee's age, their years of service, the position they hold, and their opportunities for reemployment. And generally speaking, they're going to get somewhere between 6 and 24 months notice or severance. And those are numbers that sometimes are shocking to employers, but it's important to know in advance that those kinds of obligations are going to exist for the vast majority of your employees if you don't have employment contracts that provide otherwise. Now, I've been talking about the non-union sector, and maybe Jess wants to jump in and talk a little bit about the unionized sector and what the differences are there.
Jessica, do you want to address that one?
Yeah, I mean, certainly. So if we're dealing with a unionized environment, the terms and conditions are set out in the collective agreement. And so it's critical to be reviewing the collective agreement to ascertain and determine what the layoff obligations are and termination obligations. Typically, what we tend to see is that there's a layoff provision and then at some point the seniority severs or perhaps the relationship ends. And there isn't typically the same ability to terminate without cause in the unionized environment. But it is critical to turn to the collective agreement if you are a unionized employee and if you're a member to connect with your union. Or if you're an employer to get some advice as to how the collective agreement's to be interpreted.
Right. Well, one of our questions from Crystal D, if a union member is terminated on a progressive discipline, while an active grievance is still in process, and the termination involves a potential human rights issue, does the union have a legal duty to act? And if they fail to do so, what recourse does the worker have beyond the grievance process?
Yeah, so I can jump in on that, just having spoken about unionization. In this scenario, and in all scenarios, of course, individuals are entitled not to face discrimination within the context of employment. And so if an individual feels that there has been discrimination, certainly the most appropriate course of action would be to raise it with the union and to make it clear and explain what's thought of there. And the union will then assess how they will address and respond to that particular issue of concern. If a person is not pleased with respect to the second point there, so the union would then decide if there's a way for them to file an additional grievance with respect to the potential human rights issue and or to raise it within the scope of the existing grievance. Then the second point, if the employee or the worker is not happy with the outcome because the union's not in fact taking action, unions do have a duty of fair representation to employees in the province of BC. There are certain fairly strict and key criteria to be met in order to bring successfully such a complaint, but the process for that would be to contact the Labor Relations Board. There's certainly some information on their website.
Okay, so
if I can just, jump in and add to that as well. Sorry about this. In BC, employees also have a right to go to the Human Rights Tribunal without the support of their union if they choose to do so. Even in a unionized context, that is one carved out right that employees have, is to pursue their own claim at human rights if they choose.
That's fascinating. Actually, I had no idea about that. And I think a lot of people think the union is the last word. So thank you for that. The next question I actually think is more of an accountant question. What is the true cost of an employee? So I'm actually going to segue that, with apologies to the person who asked it, and say a lot of employers say, I can't afford to hire employees yet, so I'll bring them on as contractors. But I guess, what is the difference? When is a contractor confused with an employee, and what are the legal risks of misclassifying employees as independent contractors in BC? I'm going to leave that to both of you.
I'm happy to jump in on that one. Yeah, this is a question we get quite frequently, and it's a tricky area because there's a lot of risk if an employer identifies someone as an independent contractor and it's later determined that they are in fact an employee and should not have been described as an independent contractor. And there's risk to employers from a number of perspectives, including income tax if they fail to withhold CPP and EI from the person's wages. They can owe overtime, have overtime obligations to the employee if the employee was working overtime and not being compensated for it. There are issues with WorkSafe if they've not been declared as an employee covered by WorkSafe and the premiums haven't been paid. There are human rights issues. There are quite a number of issues when an employee is mischaracterized as an independent contractor. So we look at 4 key factors to determine whether someone should be described as an employee or an independent contractor. And 2 of them are more important than the other 2, if I can put it that way. And basically, the test that we look at is how integrated is the person within the business of the organization. If this is someone who's working 40 hours a week and has an indeterminate period of time that they're going to be working for the organization, they're going to be heavily integrated. If they have a title, if they've been given, a title of general manager or something, then they look very much integrated within the organization. The second is whether the individual owns their own business. If someone owns their own business, I would use Jess and I as an example. We own our own business. We work with many, many, many different clients. When we work with our clients, we are working as independent contractors with that client. We own all of our own tools. We own our workspace. We are in control of our method of production. We are true independent contractors when we work with our clients. And so that second question of whether the individual owns their own business, it's going to look at, is there a single source of income? Is there multiple sources of income? Are you working and providing the same or similar services across a number of different agencies, or are you working exclusively with one entity? We also then look at things like who owns the tools? Are you working in your own office using your own tools, or are you actually integrated, as I said earlier, in the employer's organization? And often it's a test that's really about a spectrum. Do you look more like an employee or do you look more like an independent contractor? Sometimes the criteria will kind of pull you in both directions. And ultimately the question is going to be, which do you look more like? But I think the other part of the question maybe that was asked, and I'll jump in with this part of the answer as well. The things that you have to be aware of if you have an employment relationship rather than an independent contractual relationship are, first and foremost, you will have to pay overtime to most employees, not all, but most employees if they work more than 8 hours a day or 40 hours in a week. You do have to provide a minimum of 5 paid sick days to anyone who is an employee within your organization. You need to provide vacation pay and vacation time to anyone who is an employee within your organization. And you will need to provide notice or severance if you terminate that relationship at the end of the relationship without cause. So those are the main distinguishing factors between an employment relationship and an independent contractual one. Obviously, as well, you've got more administrative responsibilities with employees. You need to withhold taxes, CPP, EI, and remit those to Revenue Canada. You have to keep payroll records and do other things. So there are some administrative responsibilities, but the actual cost would primarily be those things I mentioned.
Yes, and that's a good point. So who then would you not have to pay overtime to? Is that like somebody in a management position, contractually? How does that work?
Absolutely. The Employment Standards Act specifies who's entitled to overtime and who's not. And first and foremost, it does provide that overtime is not required for managers. However, the Employment Standards Branch is using a more and more narrow definition of what constitutes a manager. And we see a lot of clients who label people as managers where the Employment Standards Branch would not agree that they satisfy the test for being a manager. Most professionals are also excluded. Lawyers, doctors, engineers, accountants are also excluded from the application of the Act. And then there are some very specific exclusions for things like farm workers, agricultural workers, oil and gas industry. There are some very specific industries that are identified, but the average sort of office-based worker who is not a manager is going to be entitled to overtime if they work more than 8 hours a day or 40 hours in a week.
Okay, great. This is a question I'm going to throw out to both of you, whoever would like to jump in. Well, somebody actually has asked a question here saying, what are some common hot water areas employers find themselves in regarding employment law? And I guess that echoes my question, which is, what are the top mistakes employers tend to make that lead to legal disputes, and how can we avoid them? So I'll throw that open to both of you.
Why don't you start, Jess?
Yeah, sure. I think one thing that we see quite frequently are employers who receive a complaint about an employee, or they receive information, or they observe in misconduct themselves directly, but they make assumptions and they jump to conclusions, and they don't actually engage in a careful objective analysis of all of the information and gather all of the facts before they take action. And so that can really come back to haunt employers down the road. And what is really critical and important is if there's some thought that the employee is engaged in some form of misconduct or wrongdoing, whether that's going to result in discipline or whether it's going to result ultimately in termination, it is really important that an employer engage in an objective fact-finding exercise. So they assess all of the information from the eyes of a third party who's maybe disinterested. So we often say to ourselves as we draft communication or whatnot, we're imagining it might go in front of a judge. Imagine yourself the judge at the end of the day as the employer, for example, and make sure that you've asked all of the questions that are relevant to all of the issues to be able to fully understand what happened and remove the sort of the emotion involved in order to fully understand the facts. And then you can take action, whether that is, as I said, discipline or termination ultimately. A key component, though, of all of this is if there are allegations of misconduct and you are looking into that, it is critical that the person who is the respondent, who is has been accused of the wrongdoing, be given an opportunity to fully and fairly respond to the allegations. So that person needs to have a clear understanding of what they're facing, what allegations are being considered, what misconduct is being alleged, what factors are being considered. And that needs to be set out carefully in front of that particular person to give them a fair opportunity to respond. That has to be done before decisions are made and before minds are made up in terms of whether the allegations of misconduct have taken place. And this is important whether you're in a unionized environment or whether you're non-union. And can result in different sort of impacts down the line, but is definitely an important piece and something where we're often, we're often working with employers while they navigate this and helping them through it. Or oftentimes, unfortunately, we're stepping in after they've made the decision to effect a termination, for example, and haven't engaged in this carefully thought out analysis and process. Marcia, what else have you noticed in terms of hot water?
I would say the other big one, the other sort of piece of advice that we would give clients is it's really helpful to have employment contracts that are entered at the time an employee is hired. It's very important that the employee have a copy of the employment contract in advance of starting work and that they have a chance to look at it, ask questions, perhaps get legal review if they want to before they sign it and start work. And we really want to see those contracts having in them clauses that talk about the end of the employment relationship. And I know that it can be hard it's like a prenup at the very beginning of the relationship to talk about the end of the relationship, but having that clause in an employment contract really protects both parties because both parties then know exactly what to expect if the employment relationship should need to come to an end. It's also really important to refresh those contracts when there's something that's happened. For example, if somebody's being promoted in the organization, it's really important to refresh their contract and not rely on a contract that may have been entered many years ago that has become stale over time.
Wow, that is something, and I have to admit, as an employer, I don't think I ever considered that, unless it was an obvious change of job, but refreshing the contracts and going through. So I think that's a really good piece of advice.
Thank you.
Sorry, did you have something, Jessica?
No.
Okay. I'm going to move to the next question, and AI. Everybody's talking about AI and the impacts of it. It'll be a while, as this person says, before many white-collar jobs are completely replaced by AI. But what are the short-term implications that employers should be aware of as they navigate this? Can an employee sue for wrongful dismissal if their job is replaced by a bot, for example? I'll throw that open to either of you.
Wow.
And I will suggest to the generational differences here that I think that Jess is better positioned to answer this one.
I love the question because now we're getting kind of outside of our comfort zone here. Not something that we've dealt with specifically before, I will say. Certainly not something I've dealt with, but fun to consider how AI and the development of technology is going to impact on employment for sure. In terms of questions around termination, so yeah, I think there would be no difference. So when an employee is terminated, what we call wrongful termination at common law can be two different things. One, it can be termination without reasonable notice or without the appropriate notice that Marcia was talking about earlier. And so we tend to call that wrongful termination, where an employee would come forward and there would be potentially a lawsuit. Usually it's a demand letter to start. Parties can try to settle the dispute. And if it isn't settled, then they file a lawsuit. And the lawsuit is pursuing damage, an award of damages to compensate them for this reasonable notice period. And so if an employer has an employment contract with an employee that does not specify the particular period of notice, we're in the common law reasonable notice zone. And if that employee is terminated without cause because the employer is going to turn around and implement AI bots, that employee, just like in any other scenario where they're terminated without cause, would have the ability to pursue a wrongful dismissal claim, wrongful termination claim for the damages. Now, I think one of the questions here ultimately might be, if the job is being eliminated because of automation or an AI bot, for example, would there be some additional damages that might be awarded by a court? Is that somehow going to be an additional cause of damage, or we sort of see, aggravated damages or punitive damages that are damages that the court awards in excess of a reasonable notice period to attribute for certain wrongs. I don't think so at this point in time, but it's not to say that we wouldn't see. I think first what we're more likely to see is some legislated pieces around this. So if we start to see more and more AI bots being used, our governments might act and start to implement certain requirements in terms of how employers are going to manage terminations that result in that. And you know, crystal glass, I don't know, crystal ball, I don't know, Marcia, if you have thoughts on that.
Well, in fact, our labor code for unionized employees does have a specific provision that deals with technological change and the obligations of an employer to give notice to the union if it's going to implement technological change that will impact the terms and conditions of a number of employees. So we have that in the unionized world. We don't yet, in BC at least, have a specific provision that deals with that for non-union employees.
Okay, that's interesting. Well, I wanna stay on the theme of technology here with a question for Marcia. What are the rules around employee privacy in BC, especially in regard to monitoring or surveillance? We are hearing of more and more workplaces that are surveilling when their employees are on the computer. Some employers, can they have cameras in the workplace? What do we need to know about this?
This is going to be a bit of an oversimplification, but let me just give you some general ideas that have come from all of the cases. And there have been many, many cases on these points over the last number of years. You know, the first thing is employers are entitled to have cameras in the workplace if the purpose of those cameras is security of the workplace and the workers. So, you know, we see lots of retail stores and hospitality places, rec centers and so on that have cameras in the workplace that are in large part there to protect the employees themselves and to ensure that if there is criminal action or something like that in the workplace, that there is a recording of that. There is an obligation to ensure that there's signs to say that activity is being recorded for all people. And what the case laws have generally said is the surveillance in the workplace is not meant to be a substitute for managing employees. It's not meant to be used as a way to supervise employees. It can be used as a default if there has been some misconduct, but it's not meant to be the primary way that employers are to oversee their employees. If it's going to use any kind of surveillance, it does have to give notice to the employees of what it's doing and how it's doing it and what purpose it's using it for. But if the purpose isn't a legitimate purpose, there can be consequences. It can be a breach of privacy, and there can be damages paid to an employee who has been improperly surveilled in the workplace by the employer. So the keystroke surveillance is generally not going to be acceptable. You know, the expectation is that managers will have a much more hands-on approach to managing their employees. Sometimes managers learn of misconduct because there's been money missing from a till, and so they're looking at their surveillance cameras to find out how that happened and discover that an employee was the one engaged in the misconduct. They can rely on that because it wasn't there for the purpose of surveilling the employee. But generally speaking, we're not yet in an era where video monitoring of employees or technological monitoring of employees is generally acceptable.
Okay, that's really interesting. And here's another question. I'm not sure who wants to take this. Is your firm seeing an uptick in grievances related to gig workers, Uber, for example, and what are the implications on workplace fairness?
So in order for there to be grievances about gig workers, first of all, they have to be unionized. And that's the first thing that's just starting to emerge is the potential to unionize gig workers. They typically were very difficult to unionize in the past. You know, there's not a central location where you can find them. They're very hard to determine how many gig workers an organization has. So we're still at the early stages of seeing development of unionization of gig workers, but we're certainly seeing a lot more legislative initiatives to ensure that gig workers are treated fairly. Jess, do you have any additional thoughts or comments?
No, I think that's a good point. We're really just starting to see sort of more and more the gig workers getting together and having sort of the ability to be represented by a union. So we're likely to see many more grievances as time goes on, but I haven't personally seen an increase in related ones to date.
Jess, I have a question for you. Can I, as an employee, refuse to work in an environment I believe is unsafe or discriminatory? And I guess it's going beyond that. Sure, I can refuse, but what are the legal implications for me if I refuse?
Yeah, I mean, employees have the right to refuse unsafe work, and you know, this is a right that they have. I mentioned psychological safety, so that right, you know, could be because a piece of equipment that I'm using might pose a threat to my physical safety, but it could also be that I'm working in an environment that is causing me psychological harm, and that I am, you know, refusing to work on that basis. In terms of consequences to the employee, it has to be a reasonable refusal, reasonable, genuine, based on, you know, the set of circumstances available, and particularly with respect to the psychological harm or concern for harm or risk to safety, it would definitely need to be supported by, I would suggest, medical documentation. So it would have to be sort of confirmation that that psychological safety is genuinely at risk, so to speak, in continuing to work in that environment. But firstly, it would be important to bring this to the attention reasonably of the employer, to allow the employer to take reasonable steps to address it. And, you know, in combination with that, ideally, the employee would have some information from, say, a healthcare provider that is helping to inform an employer as to how this is impacting the psychological safety. So what are the limitations and restrictions of this employee with respect to the safety in the workplace? And, you know, there are a lot of instances and a lot of situations where employers can accommodate an employee's limitations and restrictions that will allow them to continue to work safely within a work environment. That can include allowing the employee to report to a different manager, assigning the employee a different set of work, changing their work hours, allowing them to work remotely. There are lots of different things employers can do to support, and I use the word accommodate, an employee who is feeling unsafe at work due to harassment and bullying concerns. So I would certainly caution an employee against a blanket refusal to work for harassment reasons, because I don't know that that's, you know, necessarily going to be justified in a lot of circumstances.
Okay, I'm going to take a question from our listeners. And either one of you can jump in, or both. In industries where hiring is often based on who you know, favors the same cultural background, and where discipline promotions may be influenced by the cultural majority, what can an employee do if they believe these practices are creating systemic discrimination?
In BC, in the last number of years, and I'm not going to be able to put a specific number to it, the province recreated the BC Human Rights Commission, and the Human Rights Commission's role is multifold, but specifically includes educational of employers and organizations about their rights and obligations and members of the public. But the other role that they hold is to look into issues of systemic discrimination and determine whether or not workplaces may have systemic discriminatory practices. We also have pay equity laws that can unroot systemic discriminatory practices as well. But if an employee is concerned that or a prospective employee, a candidate for employment, is concerned that there may be discriminatory hiring practices, that is something that can be taken to the Human Rights Tribunal directly with a complaint against the employer to say, there is going to be an expectation that it's more than just a suspicion, that there's some evidence to support it. But you know, those cases are available to be taken to human rights if the employer has got a practice. It's not necessarily just about hiring who you know. It's whether in hiring who you know, you are closing the doors to individuals who might be protected under human rights, those with disabilities, those of racial minorities, you know, women over men. People of gender minorities, those kinds of things that are protected under human rights law. So you need to be able to demonstrate that the hiring practices actually have impacts for people in protected groups.
Okay, that's very interesting. If I can just stay with you for a minute, Marcia, can my employer terminate me while I'm on sick leave or maternity, paternal leave?
And the answer is a qualified yes, but a very significantly qualified yes. Employees can be terminated if the reasons have nothing to do with the sick leave, the maternity leave, the parental leave. If the reason is, the employer is shutting its doors and all employees are being let go, there's no special protection for those who are on a form of protected leave. The employer may still terminate. But if the reasons have anything to do with the sick leave, the maternity leave, the parental leave, then there are strong prohibitions in our laws to preclude an employer from terminating an employee in those circumstances. And that includes circumstances where the replacement employee, the employee that's been hired to backfill that employee, turns out to be a better employee. It's still potentially discriminatory to say, we just hired somebody that's better than you are at doing this job, and so therefore we're going to let you go and keep the person that's been backfilling for you. That can be found to be problematic. It can also increase the amount of notice or severance an employer may owe an employee, because severance is for the purpose of giving the employee an opportunity to find other work. And if the employee is not able to look for other work because they're on sick leave or because they're on maternity parental leave, it may expand how much notice or severance the employer is going to be obligated to give in those circumstances. So, generally speaking, it's best to wait until the person's recovered or returning to work before those decisions get made, so that the person has a legitimate opportunity to find other work. But there's no actual prohibition on terminating in those circumstances.
Okay, so then Jess, if I take maternity leave, does my employer have to guarantee me the same job to return to? Or paternity leave, I suppose.
Yeah, so maternity leave or parental leave, the employment standards legislation does require an employer to can't terminate the employee while they're on the leave. It's a job protected leave of absence. And when they return, they need to return to the same or a comparable position. And a comparable position is one that has the same level of responsibility, the same sort of type of reports in terms of direct reports and the reporting lines, the same level of compensation as well. Status, so the title, the benefit, same benefit plan and compensation, of course, hours of work, location of work, all of those factors need to be the same in order for it to be a comparable position. And notably, the burden will be on the employer if it recalls the employee to work to the position, and the employee chooses to turn it down. So the employee would have to prove that they did in fact recall the employee to work to the same or the comparable position.
Okay, let's take another question from our viewers. If you don't mind circling back, what is the legal line drawn when it comes to workplace surveillance, specifically regarding personal devices and text messages? If an employee's private messages fall outside of social media policies outlined in the employee handbook, can an employer still use them for disciplinary action?
And there are certainly circumstances when employers can use employees' text messages, their posts on Facebook, other kinds of social media things that an employee may be doing, if it has a direct impact on the workplace. And so there's a few specific examples I can think of where an employer would absolutely be able to rely on an employee's private communications. One is in the context of sexual or personal harassment. If a supervisor or a coworker is texting, sexually inappropriate comments to a coworker, even if that's outside of working hours, outside of the workplace using their own device, it's still a workplace problem that the employer is entitled to take action to address. Or if a person is going on to social media and making negative comments about the employer, that is also something an employer can legitimately address with disciplinary means. So there are some parameters in which an employer can rely on those forms of communication to address and discipline employees, including terminating them if the circumstances warrant.
Okay, interesting.
It's a very nuanced area when we start to get into this in terms of whether the device is owned by the employee or not as a personal device. Does the employee use it for work and personal, and has the employer endorsed that over time? And then all of the factors around how the employer came to know of this information. So if one of the recipients brought it, one of the participants in this exchange brought it to the attention of the employer, they're going to be more likely to be able to rely on it than if they have somehow gotten their hands on it for sort of through ulterior, motives that methods that a court or an arbitrator might frown on. So it is a complicated area once we start to sort of look at very fact specific.
What advice would you give to employers? We often see that an employer sends out an email to their team advising them of certain policy changes, or, why a certain number of employees have been laid off. Would you advise them not to email that? Because often those letters, or portions of them, can become public on social media afterwards. Sorry, I'm kind of throwing that to you. I just thought of it because you see it so often.
There's a lot to unpack in that. And the very first thing I would say is employees don't have a general right to publish information that they learn in the workplace unless it's already in the public domain. The employer's information is generally going to be confidential, and employees shouldn't be using, the self-help methods to publish information of that nature that comes to their attention in the course of their employment. So that's the first caveat. The second thing is employers have a duty to respect the privacy of their employees, and that includes not publishing information that we've just terminated such and such an employee. It is possible to say this person's no longer with the organization, but the employer shouldn't be publishing information to suggest that it made an active decision to terminate that employee's employment. It leads to speculation and question. Information about an employee's health that the employer may know, that's something else that it shouldn't be publishing to other employees without that employee's consent. So there are some concerns about what does an employer share with its employees and staff about other employees, and it has a duty to protect each individual's employees' personal circumstances. The fact that an employee works at an organization, their title, their duties, that's not personal information, but their health, their home contact information, their personal contact information, personal information about their performance, that's all information that's protected.
Okay. I'd like to just circle back to questions from our listeners. What legal obligations do unions have to process member grievances within specific timeframes? And what recourse does a member have if they believe their union or employer is intentionally delaying the grievance process? Who would like to grab that one?
I can jump in on that. When the parties are unionized, they negotiate the collective agreement, and through that process, they agree on a process typically as to how they're going to resolve their disputes. So the labor code requires them to have a process that they've agreed and outlined. And so typically the timelines are set out in the collective agreement. And in terms of those timelines, we frequently see sort of a number of steps. So initially there's a step one meeting, for example, where the grievance is raised and the parties will have a discussion to see if they can resolve it. And the union would then advance to the next step, which is sometimes now filing something in writing or having something exchanged in writing. And then the step three and then step four sometimes is referring the matter to arbitration, which is like having an arbitrator adjudicate or determine the outcome of the grievance. It is not uncommon for parties to not for a union and an employer, say, to have a practice where they don't necessarily always strictly adhere to those timelines. So sometimes practices develop, and by virtue of that, the timelines sometimes end up being longer than they are specifically stated in the collective agreement. Right. But sometimes those timelines are not adhered to, and the other party, say, the union doesn't take action in the allotted amount of time, the employer might argue that they are now out of time and they should be precluded from advancing this any further. And the strength of the employer's argument is going to turn on how strong the language is. Does the language say they must advance it, or otherwise it's deemed to be abandoned, for example? And if in practice they have always adhered to the timelines, the employer might successfully, manage to get the grievance dismissed because it's out of time. But on the flip side, if the language says they may advance it in this time, and there's not strict language around dismissing it, then they may not succeed there. To the latter sort of part of this question, if the union is intentionally delaying filing the grievance, then there may be some issues of fair representation, which you referred to earlier. I won't get into the ins and outs of sort of the requirements associated with that. There's certainly some information on the labor relations board website about what you can do, and you would contact them to file any kind of failure to properly represent
Okay.
you.
That's great. And really good answer. Can we, here's another one that came in. Can we require employees to return to the office if they were hired remotely during the pandemic and the pandemic's over? Can we legally require them to come back to the office?
So I'll jump in to say, again, it's a very nuanced question, and it's not one that warrants sort of a yes or no answer. It's very dependent on what the circumstances were when the employee was hired, what representations were made, and what language is in the offer letter or contract with the employee. If the employee is specifically being hired as a remote worker, they're going to have a much stronger argument that an employer can't unilaterally say you must return to work. But if the nature of the hire was, we're currently all working from home, but the normal place of business is, at such and such a place of business, the employer may have more rights in that circumstance. Employers sometimes, though, also have a right to give an employee notice that they're going to require them to work out of an office space or at a specific location by saying, you can continue to work at home for a period of time, but after that period of time has passed, we are going to require you to return to the workplace. And the employee really then only has a choice to say, I don't accept that and I quit, or I'm going to look for other work in the meantime because I'm not prepared to follow the employer's direction in that regard.
Okay. Is there a really good resource available you'd recommend for me, this is a listener asking, to use as a teaching document for my team to better understand the rights, responsibilities, differences between employee and contractor? So we did actually answer the question about what is the difference, but is there a good resource people can go to?
The CRA does publish information in that regard. I can't give you a specific site, but if you go to the CRA's website and look for employee versus independent contractor, there is some very good information available on that website. I do caution the use of Google to find information because it does vary jurisdiction to jurisdiction. And if you find yourself in an American website, you're going to get very different information than if you find yourself in a BC website, that has more reliable information. So using something like the CRA that's a trusted website, I would recommend.
Hey, that's good to know.
Two things there. I think the Government of British Columbia website has an ESA piece around dependent or contractor versus employee. And so that's another resource that you might want to turn to. And then sometimes, the CRA definition can be slightly different than the employment definition, which to Marcia's point, it goes to, these things can be nuanced. And so just exercise some caution in that respect.
Okay. Can my employer change my job duties, hours, or pay without my consent? Marcia, I'll throw that to you.
So there's a concept at law called constructive dismissal, and a constructive dismissal occurs when an employer unilaterally makes significant changes to an employee's employment terms and conditions. So employers have the right to make moderate changes to employees' terms and conditions. If the hours of work have always been 8 to 4, and we want to change that to 8 to 4:30. That might be an acceptable change for an employer to make, or to modify job duties along the lines of the duties you're already performing because the business is evolving. That's going to be generally acceptable. But significant changes, and in particular significant negative changes, can constitute what's called a constructive dismissal. And if the employee doesn't accept those changes, isn't prepared to accept the employer's proposal, the employee will have the right to claim constructive dismissal and claim the same kind of notice or the same kind of severance as if the employer had actually just terminated the employee's employment. But again, there's a lot of nuance to this area, and I would not recommend an employee take that decision without having some really solid information about whether they're on solid ground, whether there are additional obligations they may have or that the courts would expect. Because even if the employee chooses to leave, there is an expectation that they will make every reasonable effort to find other work. And sometimes that can include other work with the same employer. if the terms and conditions that are being offered aren't particularly egregious. If the changes are for business reasons and not directed at a specific employee. So it's an area where employees need to exercise a great deal of caution before taking that position.
Okay, good to know. Last question that we have time to take today, and there's been so many good questions. And this person is asking, does the employer have a legal duty to address a poisoned work environment before escalating to termination?
I'm happy to take that one. So employers have a legal duty to ensure a safe workplace, and WorkSafe BC does have some, speaking of resources, there are some resources there certainly to assist and support both from the employee and the employer side in terms of what the rights and obligations are. There are obligations to respond and address. Firstly, there have to be policies in place in an organization to address and ensure, issues of, and when you use the word poisoned work environment, we're almost certainly talking about some form of harassment. And we would be looking at a respect in workplace type of policy, which all employers are obligated to have in place. And so, yes, there is a legal duty to respond to that. If there is some knowledge or some concern around whether there is potentially some harassment happening in the workplace, whether there's a complaint or not, there's an obligation to inquire, address it, and follow your policy that's in place, and make sure that employees are, in fact, processes are being put in place to ensure safety. I'm not quite sure what the reference is to escalating to termination. I'm assuming that means escalating to termination in terms of terminating the person who's responsible for causing the toxic work environment, in which case I reiterate my points earlier, which is you have to do a careful fact-finding analysis to determine if the person has actually played a role and if there is just cause for termination. That will depend on the outcome of all of those findings. I do want to be cautious and raise caution here, because there's protection both to employees, both under WorkSafe and under employment standards, against retaliating against employees for having raised concerns of safety or for having raised concerns of a violation, perhaps of the Employment Standards Act. So if an employee says, hey, I haven't been paid overtime, I'm due overtime wages, and the employer turns around and terminates the employee, that would be retaliatory in nature, and it will be hard for, there may be another reason for the termination, but the employer should be very careful, because it's going to be hard to show that it wasn't connected. The same goes for an employee who says, hey, I'm suffering from a poisoned work environment. If that employee is disciplined or terminated shortly thereafter, it will look like a prohibited action, and there will in fact be an onus on the employer to prove it was not a prohibited action in that instance. So be very careful in terms of how you're managing these kinds of complaints and concerns in the workplace.
Right. Well, I've learned a lot today. I realized I had a lot of assumptions. I'm sure many of us do. So thank you both for taking the time to answer all of these questions. And you've both been fantastic, and I hope our listeners got a lot out of this. We will be posting this video next week on ourrisingeconomy.com. So you'll be able to go there and check it out. And in the meantime, what is your website? Can you share? How do people find out more about your law firm? Where will they go?
Well, one easy way is to certainly search either of our names, Victoria Lawyer. I think you'll find us. The law firm again is Pulver, Crawford, Munroe, otherwise known as PCM. And our website is pcmlawyers.ca. And so you can find us there.
Thank you both for your time. You've been fantastic, and I really appreciate it. And I'm going to turn it over to Kieran to close. Have a good day, everyone.
Thank you.
Thank you.
Kerry, and thank you, Marcia and Jessica, for your time this afternoon. Thank you to our presenting sponsor, RBC, and our Catalyst sponsor, Vancity, for supporting Rising Economy 2025. The conference is also presented in partnership with Pacificam. Thank you to all our other event sponsors that have helped make this year another great successful event. This is the final session for Rising Economy 2025. Thank you to all who participated. We look forward to working with you to further strengthen Greater Victoria's economy going forward. Have a great day and have a great weekend coming up. Thank you, everyone.